And so we are really delighted that what we're going to have today, once again, returning, she has been with us when she was in a current position, and prior to that, the Deputy Attorney General of the United States. Just very briefly, she has had a number of, a really illustrious career. She was an assistant U.S. attorney in the District of Columbia. She was in a number of other positions at the Department of Justice, on the Enron Task Force, the FBI, working for FBI Director Robert Mueller as a special counselor. She served on national security issues as Associate Deputy Attorney General. She was Principal Associate Deputy Attorney General, and she, of course, has had a variety of experience and extensive experience. As you may recall, she talked to us 2 years ago about some of the new policies of the Department of Justice, and I'm delighted that this discussion is continuing with Attorney General Merrick Garland last year, and this year again with her, and tomorrow with Kenneth Polite. So it would be wonderful to have. We are delighted, really, that the number of AAGs and senior Justice Department and rank and file staff attorney, Justice Department and U.S. attorneys and SEC, CFTC, really across the board, including civil division attorneys, has been amazing, and we're very, very thankful for really being here with us. So I'm delighted to introduce to you the Deputy Attorney General of the United States, Lisa Monaco, who will then have a Q&A with Leslie Caldwell, whom we all know. Thank you very much.
Thanks, Ray. Thank you so much, Ray. It's great to be here. Thank you very much, Ray, for the very warm welcome and the very generous introduction. Lengthy, but generous, so thank you. It's nice to see so many friends in the audience and to be back with you, although actually with you this time and not beaming in. And I'm really pleased my friend Leslie Caldwell has agreed to moderate a little discussion afterwards. I'm sure she's got a number of softballs in store for me. But it's a pleasure to be here to talk to you about an enduring Department of Justice priority: advancing the fight against corporate crime. Corporate crime, as we all know, jeopardizes jobs, savings, our economic security, and increasingly, our national security. Since returning to the department, the Attorney General and I have prioritized battling corporate crime in order to uphold the rule of law, to strengthen financial markets, and to reassure the public that no person and no company is above the law. Now, as Ray mentioned, 2 years ago in October of 2021, I directed some immediate policy changes to invigorate corporate criminal enforcement. And I did so based on a few fundamental principles: preventing misconduct before it happens, holding individual wrongdoers accountable, and deterring and punishing recidivism. Now, at the same time, we launched the Corporate Crime Advisory Group to recommend more advances based on input, and this is important, input from outside as well as inside the department. And based on that input, last fall, I announced department-wide policy changes focused on promoting cultures of compliance, while also ensuring consistency and predictability in the way the government treats corporate crime. Our goal is to empower companies to do the right thing by investing in compliance, in culture, and in good corporate citizenship, while at the same time empowering our prosecutors to hold accountable those who don't follow the law. Now, many of the policies I announced last September required action across the Department of Justice, from the criminal division to divisions that concentrate on tax and antitrust and environmental and national security crimes, to each of the 94 U.S. attorneys' offices. And today, I'll update you on the progress we've made, including our work to cement a firm foundation for corporate criminal enforcement and reward investments in corporate compliance. And I'll also address the additional resources we are bringing to bear to confront emerging risks. Because in today's complex geopolitical and very uncertain, quite frankly, geopolitical environment, corporate crime and national security are overlapping to a degree never seen before. And the department is retooling to meet that challenge. Our National Security Division will be elevating its attention to corporate crime through an infusion of personnel and expertise. And we're doubling down on the successful strategies we've developed to attack cyber and crypto crime, to harness all tools across government to pursue prevention, deterrence, and accountability. Now, last September, I emphasized the department's commitment to finding the right incentives to promote and support a culture of corporate compliance. And I noted two new areas of particular focus: a cross-department approach to promoting voluntary self-disclosure, and how compensation structures can foster responsible corporate behavior. We want companies to step up and own up when they discover misconduct, and to use compensation systems to align their executives' financial interests with the company's interests in good corporate citizenship. And since then, the department has been doing the hard work of turning principles into policy. Now, with respect to voluntary self-disclosure, I am pleased to report that for the first time, every U.S. Attorney's Office now has, and every component, I should say, that prosecutes corporate crime, now has in place an operative, predictable, and transparent voluntary self-disclosure program. These policies share a common principle. Absent aggravating factors, no department component will seek a guilty plea where a company has voluntarily self-disclosed, cooperated, and remediated the misconduct. Now, we recognize that companies and counsel rely on the department to apply its policies transparently and consistently throughout the country. By adopting one policy for all U.S. attorneys' offices, we are eliminating geographic disparities and uncertainties. The same policy applies whether a company voluntarily self-discloses to a U.S. attorney's office in Alaska or right here in Miami. Now, these are not rigid cookie-cutter policies. Each component thoughtfully tailored its policy to its specific mission. Potential aggravating factors are different for the National Security Division than they are for the Environment and Natural Resources Division. And even in the Criminal Division, which pioneered this concept and already had a model policy from which components drew, the Criminal Division revised its policy to provide clearer assurances and increased incentives for companies that come forward and self-report. Let me be very, very clear. I want every general counsel, every executive and board member to take this message to heart. Where your company discovers criminal misconduct, the pathway to the best resolution will involve prompt, voluntary self-disclosure to the Department of Justice. And the department is practicing what it preaches. For example, the Criminal Division recently entered into a deferred prosecution agreement with ABB Limited, a Swiss multinational engineering company. And this was a DPA for FCPA crimes that it attempted to voluntarily self-disclose to the government. Now, this was not the company's first DPA, and the department carefully scrutinizes this type of recidivism. But weighing the company's efforts to disclose, its extensive cooperation, its compliance program overhaul, and other key considerations like facilitating overseas employee interviews and engaging in extensive remediation, the criminal division concluded, and we agreed, that a DPA was appropriate. What this shows is that even a company with a significant history of misconduct has a powerful incentive to make a timely self-disclosure. Had ABB not promptly come forward, the result would have been drastically different. The second new policy to drive compliance-promoting behavior involves innovative approaches to compensation and the use of clawbacks. Now, last September, I announced that the department would examine corporate compensation programs to shift the burden of corporate malfeasance away from uninvolved shareholders and onto those more directly responsible. Companies should ensure that executives and employees are personally invested in promoting compliance. And nothing grabs attention or demands personal investment like having skin in the game through direct and tangible financial incentives. So, at my direction, the criminal division studied this issue. I asked them to talk to practitioners, to consult with regulators, and to develop guidance on how to reward corporations with compliance-promoting compensation programs. As Assistant Attorney General Kenneth Polite will talk about in greater detail tomorrow, we are now ready to launch the department's first ever pilot program on compensation incentives and clawbacks. Now, the program has two parts. First, every corporate resolution involving the criminal division will now include a requirement that the resolving company develop compliance-promoting criteria within its compensation and bonus system. This is something we've already debuted in recent criminal division cases with criteria that are tailored to fit the company's existing compensation program. For example, as part of its plea agreement in December, and in addition to forfeiting $2 billion, Danske, the largest bank in Denmark, agreed to revise its performance review and bonus system to include criteria related to compliance. So now Danske executives with a failing score for compliance will also fail to secure a bonus. Second, under the pilot program, the criminal division will provide fine reductions to companies who seek to claw back compensation from corporate wrongdoers. At the outset of a criminal resolution, the resolving company will pay the applicable fine minus a reserved credit equaling the amount of compensation the company is trying to claw back from the culpable executives and employees. If the company succeeds and recoups compensation from a responsible employee, the company gets to keep that clawback money and also doesn't have to pay the amount it recovered. And because we heard from stakeholders about how challenging and how expensive the pursuit of clawbacks can be, the pilot program will also ensure that those who pursue clawbacks in good faith but are unsuccessful are still eligible to receive a fine reduction. Our goal is simple: to shift the burden of corporate wrongdoing away from shareholders who frequently play no role in the misconduct onto those directly responsible. We intend this program to encourage companies who do not already factor compliance into compensation to retool their programs and get ahead of the curve. Tomorrow, we will release this new policy, and Assistant Attorney General Polite will provide more details about the program. We believe that the best way to combat corporate crime is to prevent it, or barring that, to surface it and address it head on. Now, these policies empower general counsels and compliance officers to make the case to company management, to make the case in the boardroom that investment in a robust compliance program, including a forward-leaning compensation system, is money well spent. Now, since I returned to the department, I've also looked for ways to expand the resources available to the department's prosecutors to address the evolution of corporate crime. And last year, we stood up the National Cryptocurrency Enforcement Team and the FBI's Virtual Asset Unit. Now, these investments have already been paying off. Whether you look at the over $5 billion in cryptocurrency recovered last year, or the prosecutions we've brought against dozens of crypto criminals. Today, I am pleased to announce a similar surge of resources to address a troubling trend, the intersection of corporate crime and national security. Companies are on the front lines of today's geopolitical and national security challenges. Increasingly, corporate criminal investigations carry profound national security implications. Last October, the department secured the first ever corporate guilty plea to material support for terrorism. This was from multinational construction company Lafarge SA for a scheme in which its executives brazenly paid millions to terrorist groups like ISIS in exchange for permission to operate a cement plant in Syria. Lafarge was sentenced to pay financial penalties of more than $750 million. And last week, just last week, the world marked 1 year since Russia's unprovoked invasion of Ukraine. That invasion sparked a global response from governments and companies alike, and it elevated the importance of sanctions and export control enforcement. What was once a technical area of concern for select businesses should now be at the top of every company's risk compliance chart. As I've said before, in today's world, sanctions are the new FCPA. And across the department, and indeed across the globe, we are handling corporate investigations that involve sanctions evasion in industries as varied as transportation, fintech, banking, defense, and agriculture. And to address the increasing intersection of corporate crime and national security, the department is today announcing significant restructuring and resource commitments within the National Security Division. Excuse me. That division, of course, is overseen by Assistant Attorney General Matt Olsen. We will add more than 25 new prosecutors who will investigate and prosecute sanctions evasion, export control violations, and similar economic crimes. Now, these new hires will include the National Security Division's first ever Chief Counsel for Corporate Enforcement. And starting today, the division will issue joint advisories with the Commerce and Treasury departments, akin to the FCPA guidance we have for years published jointly with the SEC, to inform the private sector about enforcement trends and to convey the department's expectations as to national security-related compliance. As Matt Olsen will talk about in more detail a little bit later today, these actions demonstrate the breadth of the department's commitment to combating corporate crime, particularly where it places our collective security at risk. As the National Security Division expands its capacity to investigate and prosecute corporate sanctions violations, they will work closely with U.S. attorneys' offices and the Criminal Division to apply enforcement strategies that have proven their worth in other areas of the department. And I am pleased to announce that we will also be making a substantial investment in the Bank Integrity Unit in the Criminal Division's Money Laundering and Asset Recovery section. As many of you know, BIU has a significant track record of prosecuting global financial institutions for sanctions violations, and these additional resources will allow it to build on that record and be a strong partner to NSD. Finally, stay tuned for some significant announcements and some significant cases in the coming weeks that implicate this very troubling trend. Let me close on what will always remain the most important priority in corporate enforcement, and that's individual accountability. Over the last 2 years, that focus on individual accountability has paid off. Recent charges, like those against Sam Bankman-Fried and Carlos Watson, and convictions, like those of Elizabeth Holmes and Sunny Balwani, demonstrate the department's resolve to take on the most challenging cases. But even more importantly, we've shown that we're serious about taking individual wrongdoers to trial. The Criminal Division's fraud section, for example, secured more individual convictions at trial last year than in any of the previous 5 years. So our message is clear. The department will zealously pursue corporate crime in any industry, and we will hold wrongdoers accountable, no matter how prominent or powerful they are. And to that end, I will close with this. An ounce of prevention is worth a pound of cure. Investing now in a robust compliance program is good for business, and it is good for our collective economic and national security. Thank you so much for having me today. I look forward to the discussion.
So thank you, Lisa, and I'm glad to hear that the department is committed, increasingly committed to transparency, because that's, from the defense lawyer side, that's incredibly important to have some level of predictability. But I guess that brings me to my first couple questions, which is, where exactly are these lines being drawn, and what are the department's expectations? So, for example, in the area of clawbacks, where does the department expect those clawbacks to occur? I mean, I've seen literature and policy statements that say clawback from people who contributed to the wrongdoing. Where is that line? Does that include people who didn't know about the wrongdoing, but it happened on their watch? And can you just flesh that out a little bit?
Sure, and as I said, Kenneth will provide more details tomorrow and will release the actual written policy, but a few principles apply here. One, we are trying to drive investment in programs that link compliance and compensation. And we understand and have been very clear, and that was the benefit of the discussions we undertook and the outreach we undertook to develop this program. So we understand that it's a complex, and as I mentioned, time-consuming and sometimes expensive endeavor. So we want to focus on those who are responsible employees. We're very aware and attuned to the danger of misuse of a clawback policy. So focusing on the individual wrongdoer, but also supervisors who had knowledge, so who were aware of the misconduct or were willfully blind, right? And so we're very clear, and you'll see this laid out in the policy, that we are focused on good faith efforts to claw back that compensation. And even if those efforts are unsuccessful, we don't want that to end up counting against the company.
So also another question about where lines are drawn. So a lot of companies, particularly large multinational companies, and I'll use the FCPA as an example just because it's a simple example, have many, many internal allegations of FCPA violations every year. Many of those turn out to be unfounded. Many of them turn out to be disgruntled employees or other folks. But they do investigate them to some level. Sometimes they hire outside counsel. Sometimes they find that, yes, there was a bribe, but it was really small.
Yep.
First of all, you use the word, and this has also been in all the policy statements, of prompt, early self-disclosure. When is that supposed to happen? Because a company that gets 100 FCPA allegations every year can't legitimately be expected to run in and tell DOJ about every single one of them before they even know whether there's any there. So what do you expect if a company investigates an FCPA allegation, maybe even determines that there was an issue, but it was small, and they fire the person? Do you expect something like that to be self-reported? And give us a sense of where these lines are.
Sure. Well, look, we recognize that these are very difficult decisions, but I also know that they're decisions and they're judgments that are made every single day by many of you, by sophisticated counsel, and companies that are highly regulated, companies that are subject to other agreements are making these calls every day. Our goal is to give you the information to make those balanced judgments, right? To be transparent, to give you the criteria that we are looking at. So that's the first point. With respect to your question about prompt, obviously it's going to depend on the facts and circumstances of the case. We know that it's going to require some digging. These are hard issues to kind of sort through, things like privilege issues, et cetera. You're going to have to do some digging to sort through them. But the company is going to be better off the sooner it provides information to us to allow us and the prosecutors to preserve evidence, to ferret out additional facts. So I would err on the side of disclosure, to your point about kind of the individual cases where maybe you found something that was a problem and you ended up remediating that conduct. Bring that forward. that is a good story to tell. The other thing I would say, Leslie, and stepping back a little bit, you know, I am not unaware of the complexities of managing a sprawling multinational corporation. Mine has 115,000 employees and about a $40 billion budget, and at any single time, in the famous words of Robert Gates, there's, in his advice to President Obama when he assumed office, at any single time, somebody in the government is doing something stupid. So fully understand that. So understand the complexities of managing a sprawling organization. But the most important thing you can do is be as transparent as possible and have that full remediation story to tell.
So if you have an FCPA, and again, keeping with that just because it's simple, an FCPA allegation that is a serious allegation, and outside counsel's engaged, and it turns out to be, in fact, there was a serious problem involving, say, regional management in some geography,
Yep.
And you decide that you're going to self-report that because you've decided, based on your experience as a defense lawyer and maybe a former department person, that this is something that would, in fact, be of interest to the department. Do you also have to self-report all those other things that you learned over the last, say, year or so that either turned out to be not a big thing or nothing? And
Well,
what are
look,
the expectations around that? And one other related question I have is, how do you, because most of these cases also involve the SEC, how do you make sure that you and the SEC are kind of on the same page about expectations?
So that second question, I think, is probably a little bit harder in the sense of what we can do is be very clear, and we talk to the SEC as we're developing these policies. We're engaged in consultations with them, but what we can do is be as transparent as possible of the judgments that we're making and the factors we are taking into account. On your question about your FCPA hypo, look, if those other violations or that other conduct is part of a similar trend, it's part of something that we might consider as something that looks systemic or has the same root causes, yeah, I would bring that forward. And I think in general, erring on the side of transparency is going to be pretty important.
And what about, so we all know that, I know in the False Claims Act context, that's a different story, but the SEC obviously has a whistleblower program, which you're not here to talk about, but there is an entire whistleblower bar that essentially seeks out allegations of wrongdoing by corporate officials, and they may know about things that a company has no idea. So there may be some internal employee who's meeting with whistleblower counsel and reporting some bribery scheme that the company doesn't even know about. Let's say the company comes forward with some unrelated issue, and you have already received a letter from the whistleblower counsel unbeknownst to the company. So the company obviously hasn't self-reported that because they don't even know about it.
Right.
What do you do? I mean, do you hold that against them?
Now look, I mean, obviously, if you don't know about it, we're going to factor that in. What we're looking at is, and this is why we're talking about promoting a culture of compliance through things like trying to incentivize through giving credit for voluntary self-disclosure. I mean, the ABB example is a very good one. This is why we're doing this pilot program with the compensation programs, trying to drive those incentives for people to come forward and make the right judgments. If the company doesn't know about what the whistleblower told the lawyer in your hypo, obviously they're not bringing it forward. But why didn't they know about it? We're going to evaluate that. What is the strength of their program to ferret that out? Right? What's their ability for that person to have come forward otherwise?
So I have one question also about the U.S. Attorney's offices. You mentioned in your talk that, that the expectation would be that you would be treated the same way in the District of Alaska as you would be in the Southern District of Florida. But I'm skeptical about how that's even possible because the cultures, and I don't know anything about Alaska and Miami, other than Willie Ferrer was a great U.S. attorney in Miami.
Here, here.
But how are you going to make sure, is there some mechanism to make sure that you are in fact, because obviously a case that's really big in Miami is probably unheard of in Alaska, and a big case in Alaska might not even be brought in Miami. How are you going to make sure that that actually plays out?
So it's a good question, and this goes to overall management and accountability for U.S. attorneys. It's why I'm talking about these issues with U.S. attorneys every 6 weeks when the AGAC comes to town. It's why we worked with the Attorney General's Advisory Committee, the leadership of about 13 or 14 different U.S. attorneys drawn from every single district, rather every single circuit, rather around the country, so we get that type of diversity of perspective, as you mentioned. It's why we rely on the leadership to monitor and enforce these policies. I think the only place you can hope to do it, the only way you can hope to do it, rather, is by having a consistent policy. And I think that's a really, really important place to start. And then you rely on your leadership who are part of developing those policies to enforce them.
So one question about the growth of the National Security Division and the addition of new lawyers. I know one challenge we had in the criminal division was that we hired a lot of really talented, smart people, but they had never been in court before. And they didn't really know, for example, how to try a case, and they were cutting their teeth on complicated fraud cases. And in this case, it sounds like it'll be something similar with complicated national security cases. How are you going to make sure that those folks have the level of skill to be able to actually do those cases effectively? And presumably they'll be working all over the country, like the fraud section does.
Yep.
How will you, what steps or what plan do you have to make sure that those people can hit the ground running?
Well, first, what I would say is the National Security Division, I know a little something about this, having led the division now 10, 12 years ago. The National Security Division, it has some experience under its belt. I mentioned the Lafarge case, which was a case brought with the National Security Division and your old office, EDNY. And I could go through some other corporate cases that they've brought in recent memory. But one of the things we want to do is build up that expertise. They will not be siloed, right? The experienced prosecutors they already have in NSD won't be siloed. They'll be working with their colleagues in the U.S. Attorney's offices, in the criminal division, to bring these types of cases. And they're going to bring in more expertise. I mentioned the chief corporate enforcement counsel that they'll hire. So I think there's also a lot of value in bringing new perspectives, new blood, new energy to what I am very concerned about, as you heard me talk about, this trend of the overlap between corporate crime and national security issues. And so I think the momentum we've already got, and we add these new resources, this new focus, and new perspectives and new energy, and couple that with existing expertise, I think we've got a great recipe.
So I think that the department has, I know from even when I was there, has sort of incrementally expanded its policies in the corporate enforcement area. What has been the result of that in terms of, are you seeing more self-reporting and more prompt self-reporting and more thorough self-reporting? Or are you just still trying to encourage that because it's still not happening?
Well, we're obviously still trying to encourage it, and that's why we now have, as I mentioned, a cross-department set of voluntary self-disclosure policies. I mean, we saw that it actually made a real difference in the criminal division, thanks to you and the work that you did, Leslie, while you led the criminal division, and your predecessors, and I see Alice Fisher here. So we saw that it could work. The National Security Division did a version of this with sanctions a couple of years ago. So we wanted to spread that experience around and get, as I said, uniformity and consistency in those self-disclosure programs. And our hope is that it does incentivize folks to come forward, especially as we make clear that there is real value in doing so. It does make a difference to, in many cases, the bottom line and to the result you're going to get. And that's why I highlighted the ABB case.
Okay, well, I'm looking at the clock, and it looks like we're out of time. Okay. So thank you.
Thank you.
Appreciate it.
Thanks for the discussion. Thanks, everyone.